A domestic assault charge generally arises from a dispute between people in a relationship. It is a crime of violence. It is taken very seriously by the courts. Domestic assaults often occur in the heat of the moment. Typically, both parties are involved in a physical altercation. Often, only one of them gets removed from the home and charged. If you are watching this video, that's probably you. If it is, listen closely. There are some things about domestic violence charges that make them different from any other charge. The first thing is, you and your partner might still want to be together. That might not be as simple as it sounds. If you were arrested by the police and then released on bail, or a promise to appear, there are usually conditions attached to your release. Two common conditions are: you have no contact with the complainant, and you can't return to where the complainant lives, even if that is where you live and all of your clothing and other items are located. Those conditions are binding on you, even if, let's say, your spouse wants you home. If you go back home because your spouse says it's okay, and your neighbor sees you, they might call the police. They know you were arrested. Your spouse told them that you weren't supposed to be there. The police will arrest you, even if they are told your spouse gave you permission to come home. You can't have contact or go back home until the condition is varied or removed. Only a judge can do that, not your spouse. Arrested on a Friday afternoon of a long weekend, you will be held in jail and might not appear before a judge until the following Tuesday. Even then, you might find it difficult to get released. To the judge, you will look like someone who didn't pay attention to the release conditions the first time. Why will you now? Release conditions or bail conditions apply if the complainant is a parent, sibling, or friend. If there's a family reunion and the complainant is there, you can't be. Finally, if you violate your release conditions, you may face additional charges. If you are facing domestic violence charges, contact a lawyer immediately to ensure you understand your release conditions. A criminal defense lawyer will know if your conditions need to be modified, and they know how to do it. Domestic violence charges also differ from other charges because the complainant often changes their mind. They want to drop the charges against you, but it's not up to them. Once a charge is laid, it's up to the prosecution, not the complainant, if it goes to court or not. Depending on the circumstances, your lawyer may be able to get the charges against you dismissed or reduced. Remember, domestic violence charges are a crime. An experienced criminal defense lawyer will get the best results possible for you. Before you enter any plea to any charge, there are 4 things you absolutely must find out from a criminal lawyer. First, can the prosecution prove its case? If it can't, you must be found not guilty. Second, do you have a defense to your charges? You might not think so, but some small detail could be the very thing that saves you. You would be surprised how often defenses are available. Third, you may be able to avoid a criminal record by entering a diversion program. A criminal lawyer knows the programs and how to get you into one. Finally, fully understand you face severe and long-lasting consequences, including jail terms and firearms restrictions if convicted of spousal assault. Even if you think you might be guilty, it is often more appropriate to resolve the cases of domestic violence outside of the criminal justice system. A criminal lawyer may be able to help you achieve this, so contact one now. Our criminal lawyers offer a free initial consultation. You can meet them and find out exactly what they can do for you. There is no obligation. You have nothing to lose. Contact a criminal lawyer here right now.